Hi, my name is Orin Kerr. I'm a law professor. Been a law professor now for over 20 years. I've taught a lot of first-year students, a lot of upper-level students, and every year about 40,000 first-year law students come into law school, and there's a lot of nervous energy, a lot of questions about what should you be doing, what's law school like, how should you go about it, how do you survive, how do you even do well? And I wanted to record this video for those that are about to start law school, just giving you a little bit of tips about what to expect and maybe how to think through the first month or so of law school. Now, some of you have lawyers in your family or you know lawyers and you've talked to them and they've given you guidance, and this video probably is not for you if you know that, or at least you will have heard some of these things before. What I'm really targeting is the group of students who don't know any lawyers or don't have people they can ask who can give them advice. So I really kind of want to read you into the program of law school and give you some idea of what to expect and what's ahead, and really just how to think about this. Now, of course, I'm just one person. This is not an official statement of law professors or an official statement of my law school. This is just my own view. So, of course, ask other people. Go online. There are books on this kind of stuff too. Whatever works for you is great. I just thought a free video posted online might be useful, at least for some folks. So I'm going to start, and I'm really going to focus on the first month of law school, focusing on the first month, because the way law school works, you've got 2 semesters typically, and that first semester is 13 weeks, and they kind of break down into maybe that first month or so, and then what happens after that. So I'm going to talk about this first month or so of law school, the first month ahead, and how to think about how to go about it. So first of all, I want to talk about the curriculum. What are these courses that you're taking? So first of all, people are probably calling you a 1L. That just means a first-year law student, 1L, out of the 3-year program. So second-year law students are 2Ls, and third-year law students are 3Ls. And you'll notice there's a specific curriculum. Your courses are set. You get this set of courses. You get the books, and they are all pre-arranged for you. And the reason why is that the first-year law school curriculum is basically standard. At every law school, it's pretty similar. There's going to be contracts and torts. There's going to be property, criminal law. There's going to be civil procedure. There's going to be legal writing. It's all sort of a standardized package of first-year classes. And so typically, they'll give you half of those classes in the first semester, the other half in the second semester. And from a standpoint of scheduling, you're just sort of given the assignments of which classes you're in and which professors you have. One consequence of that is that typically you will be with the same group of students for all or most of your classes. So typically, let's say a typical first-year law school class school-wide has, I don't know, maybe average 200, 250 students. Maybe there are 4 sections of 60 or so students. You will be in that section, and you'll have all of your classes with that same group of people. And that's why you're just sort of given that first year sort of, here are your classes memo. You're assigned your teachers, and you go forward. So why are these the classes that are in the first year? Some of this is history. Those have been the classes for a long time. But also some of it is that they're considered kind of the core of what comes later. So for example, contract law is the law of legally enforceable promises, deals, arrangements to buy something or trade something. And so that becomes the basis of commercial law, corporate law, secured transactions, other courses that are all about like business law, basically. And you get the beginning of it in contract law. Similarly, criminal law, the law of what is a crime, that then leads to criminal procedure, leads to investigations. It leads to the law of adjudicating criminal cases, white-collar crime cases. So they all kind of start with the root of the first-year criminal law course. And so by the end of the 1 year, the 2 semesters, typically, you will have that basis of all of these different areas of law, and then can pick in your second and third years whatever courses you want to take after that. So you get these courses. They'll be in different order. Usually, though, you'll get first-year civil procedure will be in the fall. A legal writing class will be in the fall to kind of get you used to how to write in a lawyerly way, how to make legal arguments. And so that will all be assigned for you. So now I want to go kind of chronologically through the process of preparing for class, going to class, what happens in class. So first, preparing for class. I want to flag an essay I wrote in 2007 called How to Read a Legal Opinion, a Guide for New Law Students. It's now almost 20 years old. How to read a case, it turns out, has not changed in the last 20 years. You can find it online for free. There's PDF readily available. And it goes through actually like what's in a legal opinion. What's in a legal opinion? It's very much a formula. When you first read a legal opinion, you think, well, this is strange. Like, I don't know what's coming where, and I don't know why this section is here. Once you've read a lot of legal opinions, it'll all just be second nature. It'll just be like, everything will be in the order you expect it to be in once you get used to it. I want to also add, in addition to that, so I sort of suggest going out, and you might find it useful to read this online essay. There are a couple extra things I wanted to add beyond that. First, in the first few weeks of law school, it's common to have old cases. So in first year criminal law, you might get a case called Dudley and Stevens. That's like a 19th century English case. Sometimes in classes, you'll start with cases from like the 1700s or even the 1600s, really early cases. They're quirky and weird. They don't read like modern cases. Why do professors start that way? Sometimes that's like a classic case. Sometimes those old opinions are really, really short, so you can read them quickly. And I wonder if sometimes they're just trying to confuse you to get used to the idea that you're reading something new. This is going to be different from the reading you've had before. Just wanted to flag that if you start preparing for your first few classes, and there are some cases that are from like the 19th century or 18th century or even earlier, that's not going to be common in law school. That's kind of a little bit of a first week or two of first year thing. Also, when you're preparing for class, actually read the materials. I know you can get summaries. You can get summaries online. You can get summaries on YouTube. You can get books of summaries. You can get AI to summarize it. There are lots and lots of resources to have someone or something else summarize what's in the opinion. Don't rely heavily on that. And the reason is not just because I'm a law professor and we want you to do the reading, although that's true. The reading is that what you're really doing, what you're really doing in that beginning, those first few weeks, is learning how to read a legal opinion. Learning when the court says this, what does it mean? When they say something else, what does that mean? And there's really no substitute for going through, doing the actual reading, and then going into class and seeing how the case is talked about, seeing how your professor reacts to it, and seeing how other people react to it, to really understand the context of a legal opinion. So especially in that first month, don't rely on outside sources. There's just a lot of value. Or you can supplement your reading through it. Maybe once you're done reading through it, fine, you can try some other supplement. But do the reading itself. It's for your benefit. A lot of times there's discussion of case briefing. Should you brief a case? What does that mean? So that's referring to writing some sort of summary, some sort of outline summary of what the case was about. Maybe you say, well, here's what the case name is, and here's what the facts were, and here's what the reasoning were. Maybe it's like a one-page overview of the case. Should you write case briefs or not? It's up to you. I think in general, students benefit from writing something down. Some sort of summary of what you read is useful because it may be you do the reading on a Tuesday and classes on Friday. And by the time you get this a Friday morning and you're thinking back to Tuesday and you're like, what was this one again? If you just have a little summary that you've written, it can be in the margins of the page. It could be on a separate page, whatever works for you. Something to refresh your memory, I think, is just useful. But that's what a case brief is. It's some sort of a way of some summary of what the case is. Up to you as to whether you write them. I think probably the first few weeks, most students find them really helpful just to get into the close reading that you need to do for law school. Also, as something beyond reading the case itself, read the syllabus. Another one law professors love to say. The syllabus that you get along with your assignments, sometimes they're very brief. They don't have a lot of information. Sometimes they have a lot of information. But often there's guidance about expectations in the class. There's guidance about how to read, what to read, all these different things that your professor is going to have. And that's really important to look through before that first class. So do read the syllabus. All right, now let's talk about class itself, which is probably what most of you are focused on. If I'm guessing correctly, if you're watching this video, you're nervous about what happens in class, about being called on, what are the expectations about class discussion. So let's talk about that. So you need to understand law school uses an immersion learning technique like learning a language in the first few weeks of class. You may have, I don't know, taken like a 9th grade, you took like a Spanish class or a French class, and you walked in the door and the teacher started speaking to you in that language, and you caught some of it, but a lot of it, you were like, I have no idea what this person's talking about. I don't know this language yet. And you were confused and you were like, I hope this all works out in the end. Why did that teacher speak to you in 9th grade in the foreign language? Well, because they're getting you used to the idea of speaking in the language, getting you used to the language. There's sort of no better way to learn a language than actually just jump in and start speaking it. And law school proceeds under that same assumption. So your professors that first day, some of them will kind of slowly, get into it, the topic for the day. Some of them will just jump right in. But in general, it's an immersion learning approach. They will act as if you are a lawyer and you can answer lawyerly questions in a lawyerly way, knowing, of course, that you won't because it's your first day. The expectations are that you won't really follow some of it, kind of similar to that 9th grade teacher who knew you weren't going to understand all of the foreign language. After all, you're just starting. But that immersion approach is similar. So what that means in part is that if you're kind of confused with some of the things that are happening, especially the first week or two, that's completely normal. That's kind of to be expected, that you'd be a bit confused as to, what exactly this means, what exactly that means. These are all questions that you can get answered, but don't think, oh, I'm confused, that means I'm not going to be good at this. It's just like that 9th grade Spanish class. Don't expect to know everything when you walk in the door. In terms of teaching styles, what you'll hear a lot about is the Socratic Method, which some professors use, usually in modified form. Some professors don't use. It really depends on the school. Some schools have professors that use it a lot, others don't. But the basic idea of the Socratic Method is that a class will consist in significant part of the professor calling on students and asking them questions, generally about the reading and generally about the cases that are assigned in the reading. Why do law professors use the Socratic Method? So there are a couple different arguments for it, but the basic idea, I think probably the most persuasive answer, is that a lot of learning law is learning the language of law. It's knowing what is a lawyerly answer to a question, a lawyerly way of thinking about a question. You think about a dispute, a crime occurs, and the court's trying to figure out if somebody is liable under a particular criminal law. That's going to be answered by reference to the legal materials that are going to focus attention on some facts and not others. The defendant was wearing a red shirt. That's irrelevant. No one cares the color of the shirt. On the other hand, other things may be quite relevant. Did the defendant realize that the person was there when he fired the gun? That could actually be what's legally relevant. And so what law professors do in asking questions is we ask the questions that we see as being legally relevant. We ask the ones that we think, basically, if you're a good lawyer and a client comes into your office and says, I have a problem, these are the questions that a good lawyer would think about. The reason law professors like to ask these questions, and the reason why they use the Socratic Method, I think at least, is because that basically trains your brain to think those questions on your own. You might have a class of 60 people. The professor's calling on one person who's answering. What are the other people in the room doing? Hopefully not on the internet or just hanging out. Hopefully they're paying attention too. They're thinking of the professor's questions and they're trying to answer them themselves. Thinking dynamically, like, how would I answer that if I were the person being called on? And the reason that's so useful is it means everybody starts to think about, what is the answer to that question? What's the answer to that question? And after a while, you'll realize it becomes kind of formulaic. You'll be able to predict what questions your professor is going to ask. And you might think like, aha, I've figured this out. I now know what questions the professor's going to ask. That's because your mind is starting to think of these questions that your professor wants you to think about, such that you'll sort of train your brain to think like a lawyer. You will naturally, when you read a case, questions will occur to you. And those are hopefully the kinds of questions that your professor would ask in class. And you will internalize that thought process through one person in your class being questioned. That's at least, I think, the idea. Different professors set this up differently. Some cold call. The idea of cold calling is just the person who's going to be called on that day for a particular case doesn't know it in advance. Some professors let people know ahead of time. Some might say there's a panel system. A panel usually means there's some preset group for each individual class. Maybe it's like 5 people that are on panel for a day. That means no one else is going to be called on to talk about cases except for those 5. Just different professors do it differently. And then some also just use a volunteer system. So that's the basic idea. You'll probably have a mix. Depends on the school where you happen to be enrolled. But some professors will cold call. Some will use a panel system. Some might just use volunteers. Some might lecture. It just varies based on that professor's style. Often there is a lot of anxiety at the beginning about being called on. That were you called on in this class yet? And oh my gosh, I can't believe. I hope I'm not called on the first day. I want you to think about what your reaction will be to this in about a month or two, which is that in all likelihood, you're going to say, being called on is no big deal. Whatever. It's just a conversation with the professor in which you talk about the reading. It's not something to be particularly worked up about. It may even be something that's actually a little bit fun, but it's not something to be nervous about. Part of that, I think, is that you need to understand how it looks from the professor's standpoint. So from the professor's standpoint, since the goal is to ask lawyerly questions and sort of test the limits of what the court said and how the court's opinion works, we as professors don't want perfect answers. Perfect answers end up actually avoiding the learning process that we're trying to have by getting representative answers. So a lot of times it'll be, for example, this is a law school classic, a case with horrible facts where you really, really want the court to come out, let's say, for the plaintiff. And instead, the court rules for the defendant. And it's one of those situations where, oh, God, if you could just craft a rule just for this one case, the plaintiff would win because the plaintiff is really sympathetic. But it turns out, since this comes up a lot, you kind of need to have a rule for the defendant, or at least that's the way courts see it. So a classic way of a law school class proceeding, when that's the kind of case that the class is reading, is that, the professor will start off sort of talking about how sympathetic the plaintiff is, and shouldn't the plaintiff be winning? And then maybe we'll get the students sort of drawn into that. And then we'll come around, well, wait a minute, if we start doing that, won't that create these problems? And then you sort of explore the problems that might result in a different rule. And then you sort of say, oh yeah, if we go in this world, we're in this sort of world, then this world, we're in this sort of world. Actually, maybe the court is better at what they did. Maybe, maybe not, but that's at least the argument basically that the professor is making, or that courts have relied on, courts generally adopted. If a student just immediately jumps to that and says, yes, that has to be the correct rule because, and maybe they've read some outline somewhere and then give the sort of classic explanation, the professor's like, well, that's not, wait a minute, we need to slow down. We need to actually go through the steps and kind of see the pros and cons. And what this means is that the professor is actually not hoping that you will beautifully answer every question that is applying the reading. Now, hopefully you get what's in the opinion. It's understood. If you don't, some things are confusing in certain opinions. But once the professor moves past, like, what are the facts of the case? What's the holding of the case? And starts talking about the implications of the rule, don't expect that you would have the perfect answer. It's totally actually probably what the professor prefers. The professor's probably wishing that students have sort of typical answers rather than perfect answers. So being called on shouldn't be a big deal because you're not being expected. You're not being graded on any of this. That's also important. It's not like if you have a correct answer, you get an A for the day. It's just This is all sort of a discussion to help everybody think through the issues raised by the reading. Part of that to think about is that when you're learning, you need to learn a couple of different things. So you're focused in the reading on learning the cases. What were the facts of each case? What were the holdings of these cases? And then ultimately that then leads to learning the rule, like what does the court say is the rule of law? And then there's a broader discussion, which a lot of professors will spend a lot of time on, which is the policy question. Should that be the rule? When I was in law school, I remember thinking that was an incredibly weird question to ask. Why is the professor so concerned with whether this is a good rule or not? My thought was, surely it was a long time ago that I went to law school. Surely by that date, common law era, surely by that date, the law must be settled. And what I did not realize was that it turns out a lot of legal issues are unsettled. Or maybe there's a rule in one jurisdiction and it's different from a rule in another jurisdiction, or there used to be a rule and it changed to another rule. And so actually the policy question is incredibly important because the answers might be unclear or they might themselves be changing. Also, you can't really understand the rule until you understand the arguments for why that rule exists. A lot of rules are basically efforts to achieve a certain policy goal. And so to understand the rule, you need to understand why the rule is there, sort of what the rule maker, whoever decided on this, was trying to achieve by that rule. So you'll have a lot of discussion in class that's not just about, what was this case and what is the rule, but how does this play out? What are the implications? Is this the best rule? Are there better rules? What would the world look like if there were a different rule? All those will be things that happen in class. Participation in class. Let me talk about talking in class outside of being called on. When you're called on, you respond. But what about volunteering? A lot of times professors will ask a question and want volunteers. Show of hands, what about this? Or does anybody want to defend this rule? And you'd raise your hand. And if the professor calls on you, you'd speak. My suggestion to you is to participate, but don't go overboard. So participating, that is trying to actively be involved. If the professor is looking for volunteers and you think you have a good answer, raise your hand and volunteer and participate. I think the reason for that is that you just learn better, and law school is more interesting if you're actively involved than if you're just kind of sitting back in your cocoon and just watching it almost like on a screen, like you are now. You just learn more. It's more fun. It's more interesting. It's more active to participate if that's something you want to do. At the same time, don't go overboard. There may be a handful of different opportunities to participate in a particular class. Don't raise your hand for all of them. Don't try to hog the space in the class. This risks becoming what gets known, a phrase you've probably heard of, being a gunner. So what is a law school gunner? The kind of classic understanding of a law school gunner is someone who wants to answer every question. They need to speak constantly. They kind of want everyone to hear their voice in class. And the reason why this is bad is that it tends to annoy classmates. It's not that they don't want to hear from people. They just want to hear from everyone. They don't want to hear a lot from any one person. This is part of the weird social dynamics of the first year, especially in the fall of law school. Some people compare it to being in high school because think about it, you're assigned classes and then typically you're in the same class with all of those people. Your contracts group is also your torts group, is also your civil procedure group. And so you should think about, well, what are the social dynamics here? I want to participate, but I don't want to speak too much. I want to respect the fact that other people have their views and other people want to answer things. So try to participate, but keep it a little bit in check. Okay, taking notes in class. Really helpful to take notes. I think for the same reason it's helpful to participate. It's a way of sort of actively learning, writing down what's going on. This is probably something you just naturally are going to do from college. Caveat to that, be cautious about how much you write down. Don't try to write everything down. Don't try to write down everything everyone says. And the reason is that the learning process is not in the writing down. When you're writing down, you're typically not thinking. You're just trying to transcribe something you hear. There's not a lot of learning going on there. During class, you should be thinking, okay, this is what the professor's saying. What does that mean? What are the, write down a couple key ideas, but try to think through what it means. So don't spend your time transcribing and not thinking. Instead, make sure you're thinking through what happens. Don't over note, because that means you're going to kind of get less out of class. Last point about class, it's the common experience of law students that you're kind of taking the professor's view of the subject rather than the subject. So you might, get Smith on civil procedure instead of civil procedure, Jones on contracts law instead of contracts law. Different professors will use different case books that use different approaches to the law, and they will offer their own takes on the law that are different. And it's a common source of concern among law students. Hey, wait a minute. I'm not really learning this subject. I'm learning this professor's take on the subject. I'm not getting my money's worth. This isn't good. So there are certainly some cases where if the professor's really giving, they're not teaching contract law, instead they're showing movies, something like that would be bad. But a lot of times the way to think about this is that in law school, you're getting a series of different approaches to law, and you're getting each area of law filtered through each particular professor. So if you end up taking, 30 different professors in the course of law school, you'll get 30 different perspectives. And that among those 30, you'll kind of get the range of views of law, which are going to be helpful when you go out and practice, and you practice before different judges. Judges are quirky too. They have their own things that they care about, just like professors. And so it's sort of a way of getting used to thinking differently about law. The more different views about law you experience, the deeper your knowledge of law will be. And it just starts there in that first year. So I guess don't see that as a problem, that you're getting a little bit of a quirky view. It's not too different from practicing law and practicing before a quirky judge, which definitely happens. That is class. Now, what about after class? So office hours. Let me talk a little bit about office hours. Some of you know exactly what office hours are, but some of you may not. So what are office hours, and should you go to them? The idea of office hours is that the professor sets aside a window of time. Maybe it's just an hour, maybe it's 2 hours, whatever, maybe more, one day a week, twice a week, whatever it might be, where the professor is going to be in their office with the door open, ready to answer student questions. So you can always contact your professor and say, I'd like to set up an appointment, especially if the office hours times don't work. But by default, the professor will be in their office ready to answer questions. The door will open and either students will be there ready to ask questions or no one will come by, just depends. But my recommendation for you as a first year 1L is to go to office hours. I think it's really useful for a couple of reasons, especially in the fall 1L year, to see your professor outside of class. The most obvious reason is to get your questions answered. So you're going to leave class with a lot of questions. And so you just can walk into your professor's office hours and say, I had these questions. And the cliche, there's no dumb questions. That's true. And especially because if you have a question that's really basic, that's telling the professor, hey, you need to step back and make sure your students understand something that you assumed was the case. So an example of this that I think comes up a lot in the beginning of law school, law professors just know the court system. There's the federal court system run by the federal government. There's the state court system run by the state government. There's trial courts at the bottom, intermediate appellate courts, Supreme Courts, and there's just sort of a structure to all of that. That's not something obvious that you're just going to walk in the door. You don't pick that up in daily life. That's typically something you're going to get once you start law school. So it may be that the professor never explained this, and the professor was saying something that made no sense at all to you because they didn't explain a basic point that you understandably didn't pick up. So that's just a great opportunity to say, I was not sure what you meant when you said the following. And then they can go, oh, wait a minute, I missed this point. Let me explain this to you. And you'll get that understanding. So obvious reason to go to office hours is just to learn, get your questions answered. There are other reasons, though. One is I think it's just helpful to feel more comfortable in law school, especially if you're somebody who's maybe a first-generation law student, a first-generation college student. You're new to this environment. Maybe you don't feel comfortable. Maybe you got a little bit of sense of imposter syndrome. Maybe you're just kind of like, I don't know if I belong here. Talking one-on-one to the professor is just a lot more useful than experiencing class only in this stadium seating where there's, like 60 other people who you see all the time and you feel might judge you if you speak. The one-on-one is really, really a great opportunity to form like some sort of like, hey, I'm over here connection. Like it's just helpful personally to have that. And then also questions about law school itself. You can ask your professor, get a little bit of advice from your professor about how to go about studying, how to go about law school more broadly. It's just a useful thing, I think. I think students, especially in the beginning of 1L year, get a lot out of that. So I do recommend doing that. Outside activities is another question that comes up. There are endless opportunities to volunteer with student groups. Probably in the beginning of orientation, there was like a student group day where they all had tables out and they were all like, come join our group. And it can be fun to get to know people through that. And it can be a great way to meet people and have different experiences. Fine. Don't overdo it, is my suggestion. Don't feel like, oh, this group that is open, I'm going to just spend a ton of time on, I don't know what it might be, like the moot court board or something like that. In your fall 1L year, especially in that first month, guard your time. Don't spend too much time on other things, especially out of a sense that like that's going to matter in terms of like resumes or something like that. That does not matter in terms of resume. You might find it useful. You might find it enjoyable. Great. But guard your time because it's going to take a lot of time to do the reading, to understand what's going on, hopefully to socialize with your classmates. Focus on that more than trying to sign up for something that you think is going to have some resume benefit, but probably won't. So guard your time in terms of outdoor activities. Another question, study groups. You'll hear this a lot. People are forming a study group. And then you'll think, oh, other people are forming a study group. Maybe I should form a study group. I'm not in all these questions sort of swirl around this. What is a study group and are they useful? The idea of a study group is just a group of people to study, really to discuss together. And so maybe the group of friends will get together and say, today we're going to discuss civil procedure. We're confused about something. And you work through it together. The thought being that as a group, you can learn more than you could one-on-one. You have a question, someone else might know the answer, and so you can learn together. Should you do this? Totally up to you. It's not obvious to me that there's like a common answer as to whether it's useful. A lot of study groups, let's be honest, turn into just socializing, which is valuable too. I'm about to talk about that in a second. That's valuable too, but it's not necessarily the case that study groups are academically important. It might just be that becomes your group of friends and you have a good time and you go to dinner and study a little bit of civil procedure. Don't think that you need to do this in order to do well in law school. It's just one of many ways that you just might find it useful to discuss the material and learn from your classmates, but don't feel pressure. I flagged this a second ago. It is useful, on the other hand, to the extent you have free time and you're in a position to do so, to socialize with your classmates, get to know your classmates. This is your life, and you are in an opportunity to get to know other people who may be your friends for life. It's not uncommon for law school classmates to end up being friends long, for the rest of their not even just careers, just their lives. And so take the opportunity to become friends with your classmates if you have that time. Some people can't. Some people are married and have kids at home, and it's just, drive in, take class, and leave because you have to. But others are, maybe you came straight from college and you're living in a law school dorm, or you're around other students, and it's just useful. Get to know your classmates. See them as future friends, and hopefully they will be. This is especially useful in the fall 1L year because remember, you're with that group in all of your classes. So you're going to see that same group in contracts and torts and CivPro and Crim, and so you're going to keep seeing them. getting to know them obviously is just, becoming friends with them is just great. It makes law school a lot more pleasant that way. Also, one of my last points here, nearing the end. Think about the first month or so of law school as a little bit distinct from the rest, or maybe a lot distinct from the rest. You've got, in a semester system, 13 or 14 weeks of class, followed by some probably brief reading period and then exams. Everybody wants to think about exams in the beginning because you've heard your law school grades are important. And it's true, your law school grades are important for most people. But that 13-week period of time before you're ever, actually 13 weeks plus reading period plus exam period, that exams are far, far away when you're starting. That means you've got a long fuse here. There's just a long, long path before you get to those exams. Think of it, my suggestion is think of the first month or so as a time not to prepare for exams. Don't think about exams yet. You don't know enough to even understand what the exams are about. You don't know enough law to read an old exam question and think of the answer because you're just starting off with the little steps here of what to learn. And you haven't gotten to the point where you can put enough pieces together so you could be tested on it. So don't think about exams in the beginning. Think about the process of learning law. You're really learning to think like a lawyer. You're learning legal reasoning. You're learning how to read a case. You're hopefully in class. Maybe the first day you didn't follow a bunch of what the professor was saying. By week 3, week 4, actually, you kind of get it now. You're like, aha, I knew that professor was going to ask that question, and I know why they're asking that question. It'll start to fall into place just what is law and how does this work? And you'll be able to, you're learning to learn law in that first month or so. Give yourself that time. Don't walk in the door the first day and think, how do I get an A in this class? Think like, how do I learn this subject? What is going on here? And then after that first month, then you can start to think about, okay, I got an exam here that's coming. I need to think about this question. So give yourself that time. Also, don't compare yourself to others. Try not to compare yourself to others. There's a line attributed to Teddy Roosevelt that comparison is the thief of joy. If you start trying to figure out how you're doing by reference to how your classmates are doing, first of all, you're going to be miserable. But second, there's no way you're going to get an accurate sense of how your classmates are doing. There's a lot of law students, if you ask them, how's it going? If they're doing great, they're going to say, oh, it's terrible. I'm just so behind. I'm working so hard. And if they're completely lost, they're going to say, oh, yeah, okay, this is easy. No problem. And so if you go based on their reactions, you might have the exact opposite impression of how they're actually doing. Don't try to compare yourself to them. Part of it may also be, people, especially first-year law students, might be a little insecure. They want to boast. Oh, my dad is a partner at this law firm, and he's going to take care of me for summer jobs or something like that. You're going to think, oh, I don't have those connections. I'm totally lost. Well, first of all, you don't know if that person actually has those connections. Second, if they have those connections, well, good for them, but you're going to do it on your own. You don't need to worry about that. You're not at that point yet. You'll be ready when you are at that point, but don't feel like a classmate who comes in and sort of is boasting about how all they have, they're so great. Don't feel like they necessarily are or that matters. Just think, okay, thanks for boasting. Take your time, especially in that first month or so. Learn how to learn law. A way of thinking about this too, I think is helpful as you study to think about there's a curve of how much you know versus how much you think you know. And at the very beginning, you very quickly reach a sense, oh, I know this. When you have about 20% knowledge, oh boy, I am really informed. I think I get it. And then as you learn more, you realize how complicated it is. And the more you learn, actually, the less you think you know. And you reach a point when you know a lot, actually, where you think, I don't know anything. Because I realize how uncertain this is. I realize how ambiguous this is. And so the student who actually knows the most and has the most subtle and rich understanding may think they don't know that much. And the student who actually does not have such a great understanding may think, I got it all. I know it all, because they don't realize how much there is to know. So don't get stuck playing the psychological game of, do I know enough? I don't think I know it. I don't think I'm good at this. Trust in yourself, go through the process, do the reading, and it will work out by virtue of you taking the steps that tend to lead to success. Doing the reading, going to office hours, whatever it might be, and don't be too distracted by what other people are saying. And then lastly, just to wrap up, I hope you'll take a moment to reflect on the fact that the first year of law school, it can be stressful, but it's also a pretty special time. Every lawyer remembers the beginning of their first year of law school. They remember that first day or that first month. The rest of law school may be a blur. 3L year, no one remembers, but that fall of first year, people tend to remember. It's a special time when you're learning about a new subject, you're learning a new field, you're learning a new profession. And I hope you will take that moment and reflect and just think to yourself, this is actually, in addition to stressful, kind of fun, pretty exciting. And I hope you have a sense of excitement as to where it goes. So good luck and enjoy that first month of law school.